Welcome to Guardianship and Conservatorship of Adults 101. My name is Tim McKinney. I'm a lawyer with the firm of Reynolds and Nicholson, and I'll be your instructor. Guardians and conservators for adults accept the responsibility of caring for an adult and his or her property. It's an awesome responsibility, and as part of the volunteer work that my firm does, we're trying to help you understand exactly what's required of you. Before we get started, though, let's go around the room and briefly introduce ourselves.
I'll start off. I'm Fred Huff. I'm the guardian and conservator for my Uncle Darrell, who's battling colon cancer and he just can't take care of himself anymore.
I'm Lynn Cosgrove, and I'm here as guardian and conservator of my father. And all he really cares about is living at home and not in a nursing home.
I'm Devin Brusack, and I'm here because my developmentally challenged daughter has reached the legal age, and now I'm being told that I have to become her guardian and conservator, whether I like it or not.
Hi, I'm Alicia Hallman. I'm here to become my mother's guardian. My brother, sister, and I take care of her together.
Okay, interesting group. Let's get started with some basic definitions. Ward, guardian, conservator. What do they mean? A ward is an adult who's been found by a court to be incapable of making important, responsible decisions about his own well-being and safety or about the management of his own property. A guardian is a person who's been given legal authority to make important decisions in the best interest of the ward concerning his or her person, much like a parent does for a minor child. And a conservator is a person who's been given legal authority over the money and property of the ward. A conservator is entrusted to manage the assets in the best interest of the ward. We see then that a guardian takes care of the well-being of the ward as a person, and a conservator manages the ward's property and money. Let's talk about the guardian's responsibilities. A guardian has the legal obligation to provide for the care, health, support, and welfare of the ward within the ward's means. The guardian determines the best place for the ward to live, ensures that the ward gets the medical attention he needs, assures that his needs are being met, and spends enough time with the ward to know how he's doing both mentally and physically.
Tim, what if my mother gets to the point where she'd be better off in an assisted care facility, but I know she's going to hate me if I move her out of her home?
Well, that's a tough issue, but it comes up often. The most important thing is not to delay making a decision like this until something unfortunate happens. If your mother's at risk of harm to herself, then you should change your living arrangement. Guardianship isn't a popularity contest. Things can get tense, but you have to do what's best for your ward, even if she doesn't appreciate what you're doing. So we see that being a good guardian means treating your ward with dignity and respect as you'd want to be treated, and making sure that your ward is protected while letting him be as self-sufficient as possible and participate in decisions to the greatest extent possible. On the flip side, your ward has certain rights, most important, the right to a guardian who acts in his or her best interest and is going to visit often enough to understand and meet the ward's needs. The ward also has the right to communicate freely and privately with anyone he chooses.
Tim, I have a question. I really don't want my father having anything to do with my brother, Brian, who has written checks on a joint account that he held with my father, but the money was all Dad's. Can I actually cut off communication between him and my brother?
Well, generally, a guardian cannot restrict a ward's communication with anyone without a court order, but since you're taking control of your father's funds, that should take care of any further problems with his bank account. Unless Brian were also physically or verbally abusing your father, I don't think that restricting visitation would be approved by the court. Now, maybe there can be better communication between Brian, you, and your dad so that everyone works together for his best interests. Now, that's not to say that you can't intervene if your father were in danger. For example, if Brian or someone else wanted to drive your father somewhere while intoxicated. Now, a ward has a right to the least restrictive form of guardianship, especially as it applies to his or her living arrangement, and also to have his or her rights restored should his condition improve sufficiently. Unless the court rules otherwise, a ward can still vote and make a will, but cannot marry. However, in making moral and ethical decisions, particularly those involving life support, it actually does not matter what the guardian's opinion is. You're required to do as your ward would want you to do. That is, to make the decision that your ward would make, even if you personally feel very differently. Okay, next, let's move on to your reporting responsibilities as guardian. You are required to file with the court what is called a personal status report within 60 days of your appointment, and then every year after that, within 60 days of the anniversary of your appointment. It's not a difficult form and should take only a few minutes to complete. The form may vary from county to county, but basically you'll report on the general mental and physical condition of your ward. The court will want to know whether there have been any changes in your ward's condition that might require a change in the guardianship. You'll also be asked how the needs of your ward are being met, where the ward is living, if he or she is happy with the living arrangement, and if you recommend a change in the living arrangement. You may be asked about your ward's social activities, how often you visit your ward, and what you do during those visits. If you receive any funds for the care and support of your ward, you'll be asked to account for these funds.
Excuse me, I still don't understand why I have to be here. I've done an excellent job of raising my daughter for 18 years. But now that she's 18, I have to explain every step I take to the court?
I can understand that feels very intrusive to you. While your daughter was a minor, you had the right to make all the important decisions for her as her parent. But you see, that legal authority ended when she became an adult. Now, the only way for you to once again have all the legal authority you had before she turned 18 is for you to become her legal guardian.
Whatever, great. That may be the law, but it makes no sense to me.
Okay, so let's shift our focus to the responsibilities of a conservator. A conservator is entrusted to manage and account for the funds and property of his ward. Your core responsibilities include the protection and preservation of the ward's assets, the collection of all income, and the payment of all debts and expenses. It's very important to avoid conflicts of interest and potential conflicts of interest in conservatorships. Before being appointed, a nominated conservator must disclose to the court any existing potential conflicts of interest, such as jointly owned property and investments, and any joint accounts held with the ward. While serving, a conservator must also disclose to the court any conflicts of interest that arise. Therefore, during the conservatorship, avoid creating conflicts of interest. Don't create any new joint accounts or joint investments. Don't buy or sell property or services to or from the conservatorship. And don't hire your relatives or friends to perform services for the ward at a rate higher than what is reasonable. Things like that. Keep everything you do with your ward's money and property above board and honest. And when you file a petition to become a conservator, you must also file an estimate of your ward's net worth, which is everything of value your ward owns minus any debts or liabilities your ward may have. Then you have to post what is called a surety bond to cover the value of your ward's personal property, plus 1 year of his income. Anyone know what a surety bond is?
It's like insurance that the ward's money will be there even if you mess up.
Excellent. Every conservator is required to post a surety bond so that if the conservator mismanages, misappropriates, or loses the ward's funds, the ward won't suffer loss.
I heard it's getting more and more difficult for people to get bonds for conservatorships.
Unfortunately, that's true, and it's one of the reasons why the county conservator gets so many appointments. If someone has a bad credit history, or has been in bankruptcy, or is unemployed, he or she usually can't get a bond. Bonding company just considers them too great a risk.
This is getting interesting. So what's the worst thing a bonding company can do if you misappropriate your ward's money? Let's say you blow it all on a Hawaiian vacation, or you pay off your car loan.
Believe me, you don't want to know. But I've got a DVD we'll play a little bit later on that shows you the worst that can happen. For now, though, let's talk about what it means to use your ward's funds for his or her benefit. What does that mean to you, Lynn?
Yeah, I've actually been thinking about that a lot, and it sounds simple, but it's not really, because you want to do all that you can for your ward, but you also have to make sure that his funds last throughout his lifetime. And you don't know how long that's going to be.
I think you're beginning to get an appreciation of how difficult your responsibilities can be. And naturally, it's desirable to maintain the usual style of living of your ward, but if he's been living beyond his means, you must rein in the spending, if at all possible, to a level that can be sustained for the rest of his life. On the other hand, when sufficient funds are available, you shouldn't spend money unnecessarily. Leaving something behind for loved ones may be very important to your ward.
What if you know at some point your ward is going to run out of money?
You definitely don't want to wait till the funds are all gone before you put a strategy in place. There are some steps you should consider taking before that. Now, once your ward's assets are used up, he or she may qualify for Medicaid benefits. But there are certain assets that are exempt from Medicaid purposes, such as a burial fund, a prepaid funeral, and some others. In some cases, your ward may qualify to have a special needs trust, with funds to be used to pay for your ward's special needs not covered by Medicaid. Just be aware that the laws governing Medicaid and special needs trusts are complex and constantly changing, and these issues and your ward situation should be discussed with an elder law or special needs trust attorney.
Gee, McKinney, this special needs trust stuff is actually pretty interesting. I may even start taking notes.
Well, thanks, I think. Oh, by the way, Devin, I just want you to be sure you're aware that you may not actually have to become conservator for your daughter. If she has no property other than her personal effects and her only income is from Social Security, which is already payable to you as the representative payee, there would be no need for a conservator.
Okay, thanks. I didn't realize that. And my case may just be what you described.
Okay, so let's switch gears now and talk about money management. Let's say your ward owns investments, such as stocks, rental property, or real estate. What might you be thinking about? Fred?
Well, I guess if the asset can be earning an income, that's probably the best place for it.
Right, because normally you would want to use any income-producing assets to help support your ward. On the other hand, when dealing with certain kinds of property, like rental property, you have to ask yourself if handling it is really for you. What else?
If your ward owns stock, you might want to consider putting it in a less risky investment vehicle.
That may be a very good idea. A conservator can retain stock investments that come into the conservatorship, but a conservator is only allowed to make new investments in what are called legal investments, which are certificates of deposit, money market accounts, obligations of the United States government or the state of Georgia, savings bonds, and municipal bonds. You would need court authorization for any other investments, such as real estate, stocks, mutual funds, or bonds, all of which are considered to be risk investments. It might be appropriate to consult with a stockbroker or a certified financial planner if you feel the size of your ward's estate warrants it. What if your ward has to move out of his home? Alicia?
Well, if you've got an empty house that's eating up money and not providing anything, I guess you'd be better off turning it to rental property or selling it.
Well, most likely yes, but you'd still have to consider whether it was in the ward's best interest if you rent it or sell it.
Yeah, my dad would rather die than give up the old homestead, so I know he'd definitely want us to keep it in the family.
Case in point, that there's not always an easy answer. However, should you decide it was best to sell, you'd have to petition the court, and the court would review the proposed sale and determine if the sale and the terms were in the ward's best interest.
Well, do you have to get permission to sell a car if your ward no longer drives?
Yes, and keep in mind the potential liability if someone else is driving the car.
If the ward has investment property, wouldn't you want to hold on to it for as long as it's appreciating in value?
Generally, yes. Preserving assets is part of your job, but it all depends on the market and the type of investment property. It's best if you can get some objective confirmation of its actual market appreciation to know what to do. Sales of property are generally allowed when it's necessary to provide for the care and support of your ward. You must petition the court to sell any property, and before doing so, you also have to consider whether there are any tax consequences to selling the property.
Tim, this is getting a little confusing. So how do I know when I have to ask the court's permission to do something?
Okay, you cannot sell, rent, exchange, assign, mortgage, or give away any of your ward's real or personal property without court authority. So, for instance, if you needed to sell something in the conservatorship to support the ward, you would file a petition for leave to sell. The only exception is that you can sell but not buy regularly listed stocks or bonds. The conservator may not spend more than the ward's annual income without court approval. Income consists of anything your ward earns, any retirement and/or Social Security benefits received, plus all interest and other income from investments. Another way of saying this is you can't spend any part of your ward's principal without authority from the court. Principal, or corpus as it's sometimes called, consists of the assets in the conservatorship. even if your expenditures are obviously in the best interest of your ward. If your total expenditures would exceed the annual income, you must obtain court authority to encroach into the corpus. Now, the court will determine if the expenses are reasonable and in keeping with your ward's lifestyle. Now, anytime you're unsure of whether an action or expense requires the court's permission, you should find out first. Acting without proper authority is one of the biggest problems the court has with conservators and guardians. Now, court clerks can usually tell you when the court's authority is required. However, court clerks cannot and will not give you legal advice. You should maintain a relationship with your lawyer because you may need to consult with him or her from time to time. Okay, next. Let's talk about getting property transferred over to you as conservator and setting up bank accounts. First, using your letters of conservatorship, which is the court document identifying you as conservator, you must get all of your ward's property titled or registered in your fiduciary capacity as conservator. Set up everything so that the title, account, or deed would read, for example, Lynn Cosgrove as conservator for...
William Cosgrove, and it still belongs to him, right?
Exactly. Whatever comes into a conservatorship is still owned by the ward. The conservator is just managing it. And remember to make it clear to the bank that you're setting up a conservatorship account, not joint or custodial accounts. If your ward holds joint bank accounts, you'll have to separate out the ward's funds, unless the court specifically allows the joint account to continue. Now, in order to determine how much money belongs to your ward, you may have to determine how much of the funds were originally deposited by your ward. Now, Lynn, you said that the money in your father's account was all his?
Yep, he deposited every penny of it.
And I assume that you withdrew whatever money was remaining in the joint account and opened a new conservatorship account?
I did.
Good. And while we're talking about new conservatorship accounts, you may want to open up both a checking and a money market account. It's usually a good idea to leave a little money in any old accounts for a month or so you don't miss any outstanding checks, automatic withdrawals, or deposits while things are getting sorted out.
I know this must sound like a dumb question, but how do you know if you have all the bills and invoices that need to be paid?
Actually, it's a very good question. You can start by looking over the last 3 to 6 months of bank statements, which will show you the direct deposits, the automatic withdrawals, and any checks that were written on the account. It'll also show you all or most of the bills. To be sure you have all of them, though, be sure to file a change of address card with the post office and have all of your ward's mail forwarded to you as conservator. That's how you'll find any others. And remember that all funds must be invested only in legal investments, which are certificates of deposit, money market accounts, obligations of the United States government or the state of Georgia, savings bonds, and municipal bonds. You can get a complete list from the court. Next, let's talk about the benefits of good record keeping. There are financial reports which you must file, and your accounting has to be accurate. The only way you're going to be able to do that is by keeping good records. Remember that you can be held personally liable for expenditures if you're not able to account for them. So you're going to be your ward's bookkeeper, and your records are going to be audited every year by the court. Therefore, it is important that you always pay by check and write the information in the check register. Note who the check was made out to, the amount, and the purpose for the expenditure. Now, you and I might not usually write down the purpose for every check, but you must do so as a conservator. Get a receipt whenever possible. Never pay with cash unless you absolutely must, and never use an ATM for withdrawals on your ward's account. Keep all bank statements and canceled checks. Keep all of your records together in one place, perhaps organized in separate files for receipts, tax records, and court filings. The first 60 days after your appointment is your opportunity to make sure your ward's finances are organized and under control, that all bills are paid, that homeowners' insurance is up to date, and any health or life insurance premiums have been paid. Collect and destroy all credit cards and notify any banks, credit card companies, and the 3 reporting agencies to stop any future activity on credit cards. Once you have your ward's finances organized, you're ready to prepare your first court filing, the Inventory and Asset Management Plan. You're required to file this plan within 2 months of your appointment. The form is standard throughout Georgia, and as you can see here on the first part of the report, the inventory section, you'll describe and list the current value of all the assets your ward owns. Any real property, bank accounts, funds, jewelry, cars, property, stocks, furniture, anything, clothing, anything of value. Then you'll list all of your ward's liabilities, mortgages, car loans, credit card, and personal debt. The second part of this report contains your plan for managing your ward's money, where you prepare a budget of the anticipated income and expenses of your ward. You're asked to come up with a monthly figure for expenses such as food, gas, and electricity. Taking figures from 3 or 4 different months and averaging them together will give you a realistic picture of your true monthly expenses. And once you have a preliminary budget worked out, you must consider how long this conservatorship might last. You must decide whether the monthly expenses are in line with your ward's income. Ask yourself if the current lifestyle can be maintained for the rest of your ward's life expectancy. If not, the budget must be brought in line with the ward's income. If it can't be, then it's likely you'll eventually deplete all of your ward's assets. So, this is just like budgeting your own income and expenses. If your ward's income is sufficient to pay his or her usual living expenses, you're probably not going to run into problems, especially if you're keeping a close eye on expenses. Any unexpected expenses can usually be covered by petitions to encroach. But when there's not enough income to support the ward's lifestyle, the real planning starts. If your ward has other assets, you must plan how to best use them to support your ward as well as you can for as long as you can. If your ward has no assets, you must maintain your ward within his or her income as best you can. You cannot borrow money without authority from the court, and you aren't allowed to support your ward on credit. When preparing a budget, keep in mind that there's a court cost for each petition filed as well as for filing the required inventory and annual returns. When you can include an encroachment request in the regular budget you present when you file an inventory or annual return, you'll save the time and expense over filing separate encroachments.
Tim, I see what it is you're asking us to do here, but honestly, I think that I could really use some professional help with all of it.
Well, depending upon the complexity of your ward's finances and the size of the estate, getting financial advice from an accountant or a financial planner could be money very well spent from the ward's account, so you may want to do that. Okay, next, let's discuss the annual return, a report that's filed every year within 60 days of the anniversary of your appointment. Now, with every annual return, you'll also file an inventory and asset management plan, updated with any new information. There's not currently a standard form for the annual return, so yours may look a little different than this one. Now, on the form we're using for this class, you're to give the beginning and ending balance for each account held by you for the ward, as well as the total of all receipts and expenditures for each account. So, looking at just the first account listed here, there was a beginning balance of $22,694 plus $18,453 in total receipts, minus $17,248 in expenditures, leaving an ending balance of $23,899. You'll also be required to submit an original statement or certificate signed by a bank employee for each account verifying the ending balance. First page of the actual return is a summary accounting, combining the totals from all the accounts. Your bond may have to be increased or decreased based on the combined ending balance, but that'll be for the court to decide. On the next page, you'll be requested to show all transactions that took place during the previous year for each account, including every deposit and deduction, the date, check number, payee, and purpose. Now, 2 things before we conclude. First, I do want to make sure that you're aware that as conservator, you have the legal obligation to file your ward's tax returns. Penalties can be assessed against you personally for late filing or for the failure to file a return. Depending upon the size and complexity of your ward's estate, you may want to seek the help of a tax preparer. Second, you may be interested to know that you are legally entitled to compensation for performing some of your duties, though many conservators prefer not to accept any compensation for the work they do. Now, guardians are not entitled to compensation, but are entitled to reimbursement for reasonable out-of-pocket expenses incurred in the performance of their duties. Now, a guardian who is not also a conservator would present the request for reimbursement to the conservator. If there is no conservator, of course, there may be no funds available for reimbursement. Now, a conservator is also entitled to reimbursement for reasonable out-of-pocket expenses, but a conservator is also entitled to a commission of 2.5% of all monies received into the ward's estate and 2.5% of all monies paid out of the ward's estate. A conservator may receive a 10% commission on all interest income earned each year, but not in addition to the 2.5% on receipts. Well, that almost wraps things up. But before we do, many conservators and guardians have asked us what happens if they fall short in their responsibilities. To answer that question, the court has prepared this short DVD.
Therefore, judgment will be rendered against the former conservator and the surety in the amount of $29,812.78 plus all costs of court. Mr. Jones, you and the surety are hereby ordered to pay over those amounts within 10 days. Your failure to do so may cause you to be held in contempt of court. You are excused.
We need to talk about how we're going to set up these payments.
Most guardians and conservators carry out their responsibilities with little difficulty. There are those, however, who will not take the obligation seriously, who will not adequately fulfill the reporting requirements, and even a few who will actually take a ward's money and spend it on themselves. Complaints may come from professionals, agencies, or even family members. But the problem most often starts, as it did in the case I've just tried, when a conservator fails to file a return on time. The court mails the conservator notice to do so, which goes unanswered. Then a deputy sheriff shows up at the conservator's home, serving him notice to appear in court. There, the conservator must explain to the judge why he has not complied with the law and why he should not be removed.
Your Honor, please keep in mind that this is the first time that my client has been called into court.
Your Honor, we respectfully request that Mr. Jones be given a second opportunity to file that return.
Even if the judge decides not to remove the conservator, there will be costs and expenses which must be paid out of the conservator's pocket. If, however, the judge finds that monies have been mismanaged by the conservator will be removed, and a judgment will be entered against the conservator and the bonding company. If the conservator does not promptly pay the judgment, the bonding company must. The bonding company will then pursue collection from the former conservator. It might garnish his wages or bank accounts. It will add interest on the outstanding balance. These actions usually adversely affect the conservator's credit rating, making it difficult for him to buy a car or obtain any other credit. If there has been theft, fraud, or any other criminal activity, including perjury to cover the matter up, the court might turn the case over to the district attorney for criminal prosecution. In the end, the conservator's reputation might just be ruined forever among family members and friends. That's why if you think the responsibilities of handling another person's money might just be too great for you, it's best to leave it in the hands of another, such as the county conservator. As a probate judge, I took an oath to perform the duties of this office, which include requiring all guardians and conservators to comply with their duties. As a guardian or conservator, you too take an oath that you will well and truly perform your duties. Unfortunately, when a guardian or conservator doesn't play by the rules, the court must take corrective action, which at times can be harsh. We trust that by having watched Attorney McKinney's great Guardianship and Conservatorship 101 course, you will never find yourself in that position.
Well, this really does conclude our class. But before excusing you, I want to tell you about some resources that may be helpful as you serve as a guardian or conservator. First, your court may provide you a handbook for guardians and conservators for adults in Georgia, which covers most of what was covered in this class. And you may want to visit the Georgia Council of Probate Court Judges website at www.gaprobate.org. There you'll find a great deal of information, including the handbook, if you didn't receive one, and links to many probate court websites. I thank you for coming. Thanks for your attention and your observations, and I know you're all just going to do a great job as guardians and conservators. Thanks.
Sure, absolutely. Take it.